Do you actually own the work that you paid someone to do for your business? Let me give you an example. You hired a designer to create a logo for your business. You signed a services agreement with them, you paid them, you started using your logo. But what if you never actually owned the copyright in that logo design? In fact, what if the designer owns the rights in that copyright? Now, I know you think probably, well, that can't be. I paid for it and I hired them to do it for me. Well, under the Copyright Act in the United States, unfortunately, the rule is very clear that if you hire a contractor, so they're not a W-2 employee in your business, but they're an independent contractor, an outside vendor, services provider, if you hire someone like that to do work for your business, to create anything for you, then that vendor or independent contractor owns the copyright in what they created for you, even though you hired them to do it, told them to do it, maybe gave them parameters and paid them for it. They own the rights. So understand that under the Copyright Act, copyright and the rights in a copyright does not automatically transfer to you upon payment or even upon engagement or completion of the work. Without a written assignment or what's called a work for hire agreement, the creator of those assets that you're hiring someone to create for you retains the rights. And this covers a broad range of brand assets and content that you might hire somebody to do for you. So let me give you some examples. It would include the logos that you use in your business. It would include the any graphic design you use in your business. It would include the design and layout, look and feel of your website. It would include the copy on your website. It would include the copy in anything that you had a copywriter create for you, from an article, a blog post, to someone ghostwriting a book for you, writing a script for you. Those things are all copyrightable items, but they're going to be owned by the contractor unless you have a work for hire provision. Videos are also the same. Photography. So if you have somebody take pictures of you for your branding and you don't have a work for hire provision in place with that photographer, the photographer owns the rights to the photographs of you. And so it goes on and on. There's all sorts of things that somebody could be creating for your business that they would actually own the rights in, and you won't, without having the right legal language in place in that relationship. So let me give you an example. Say a startup hired a graphic designer to design its branding, and its website, its logo, the look and feel of all of that. And the agreement between you or that startup and the designer did not say anything about the assignment of the copyright or legal rights in those creations. Well, so then that founder started using those items and went to go get the logo registered as a trademark for its brand, which you would think they should be able to do. It's their logo. Well, the designer had not released the copyrights in it, and the designer could actually prevent that owner from getting a trademark in the copyright, because you have to own the copyright in the design before you can actually get a trademark in it. So that's a really big problem. So you have to find a way to get the designer to assign the rights to you as the business owner so that you can use it without that creator ultimately being able to interfere with your ability to use that design later down the road. And also, if the creator, if the designer owns the rights, they can also use that design for other people, and you cannot stop them because the copyright owner has the ability to make what are considered derivative rights or copies of their work and use it for other purposes. And so you have to make sure that whatever agreement you have in place with your designers, with your content creators, copywriters, etc., videographers, photographers, even if you're having music designed or created, for your videos, for example, or for events, you have to make sure you have in place with all of those people language that is called work for hire. And if the work is already done, so it's after the fact now, then you need to get a copyright assignment from them. And so it's very important to do this before you can claim ownership on those things, before you can get a registered copyright in any of those items. And so it's important to do. And ideally, you're going to do that up front. And by the way, if that happens and the designer ends up interfering with you, you may be forced to rebrand, maybe with a different designer, and incur the expensive cost of not only having to pay for a new logo, new branding, new website, but then you also have to educate your target audience and your past, customers or clients about your new brand and the new branding, and so they recognize you again, and so it could be extremely expensive for you to deal with that in your business. So let me give you 3 action steps on how to protect yourself when it comes to dealing with things that you're having outside vendors or independent contractors create for you on your behalf. First and foremost, most importantly, have a seasoned copyright lawyer include intellectual property transfer clauses or work for hire agreements in all contractor agreements. This should just be a standard thing that you do in anyone that you hire to do work for your business. Secondly, make sure you register those key assets with the Copyright Office. Once you have the ownership rights, make sure that you get registered copyrights in anything that you don't want anyone copying. If it's important to your branding, or if it's important to your business, maybe it's content that is your proprietary content, your original creation, and you don't want anybody else to be able to use it, you need to get copyright registration to protect those rights. And three, you need to audit legacy content and branding, and having a seasoned copyright lawyer to do that is the way you do it. Have them come in, and this is something that I do for my clients all the time, to look at prior agreements that you have with your designers and content creators and make sure that those gaps are cleaned up by having these copyright assignment agreements put into place after the fact in a way that makes them enforceable, which there's some tricks to that. So you need to make sure you use a good copyright lawyer to get those agreements in place. So if this is stressing you out, and it often does because most of my clients do not understand this about copyright law in the US, so just book a call with me and let's make sure that you are the owner of the work that you have paid for, and there are no doubts about that.